The First District Court of Appeals is back in session.
So now we have our third case that is set for argument this morning that's being argued by Zoom. This is case number C-220500, in re Estate of Anne Kathleen Jordan. So we have Mr. Jordan, who is arguing for himself this morning. Good morning, Mr. Jordan.
Good morning.
And we have Attorney Sauter, who is arguing on behalf of the appellee. Good morning, Attorney Sauter.
Good morning.
Okay. Mr. Jordan, in your argument this morning, you're going to have 15 minutes to present your appeal. Of those 15 minutes, you can reserve whatever amount of the 15 minutes that you like. So let's say you were to reserve 5 minutes, then you would argue for 10 minutes. And then the 5 minutes that you reserve would be used to respond to Mr. Sauter's argument. Do you understand that?
Yes, ma'am.
Okay,
Yes,
so how much of the 15 minutes would you like to reserve to respond to Attorney Sauter's argument?
I think five minutes should be sufficient.
Okay, so you're going to argue for 10 minutes. I'll be keeping track of time, and you can begin whenever you're ready.
All right. First, I'd like to say I'm sorry I have any service interruptions. I've been involved in a natural disaster recently, and service is very limited. So I have dropped service a few times in the waiting room. I'm sorry in advance if I do. Second off, through this whole experience, the loss of my mother, if you would have told me prior to this that, this is the way that the courts are conducted and the judicial experience that I was going to have, I would have told you you're crazy. But, I stand before you today deeply concerned about the grave injustices and the legal errors that have plagued this case from the very beginning. The circumstances surrounding this appeal are rife with the breaches of law, rights, and equity.
Mr. Jordan, I have a question for you.
Yes.
I want to make sure that you are aware that there are pending felony charges against you in the Hamilton County Trial Court, and that you have a right to an attorney to represent you in those cases. I know you haven't been arraigned there, but you do have a right to an attorney there. And an attorney in that case could help you understand how that case intersects with this one and how anything that you might say here could be used in that case. I also want to make sure you understand that we can resolve your appeal on the briefs, and you do not have to argue today. We have read your briefs and we can decide your case without an oral argument if that's what you would prefer. Do you want to go forward in light of those circumstances?
Are you informing me that as a pro se litigant, I shouldn't be speaking on my own behalf?
I can't give you any legal advice, sir. I just want to make sure that you're aware of the pending charges and that you do have a right to counsel there, and you can make choices based on that.
Okay, understand. I appreciate you bringing my attention.
And we're having a little difficulty hearing you.
So he had mentioned earlier that he was having trouble with the call dropping while he was in the wait room. So the call just dropped. So why don't we?
The circumstances that surround this appeal are ripe with the breaches of law, rights, equity. They cannot be ignored. Before delving into the legal aspects, let me provide some context. I did not seek to become the executor of this in question, but circumstances into this role had abandoned their responsibilities on the day of the decedent's passing. The Hamilton County Sheriff's Office failed to secure the decedent's property, leading to the theft of valuable assets and financial information. This created a chaotic environment, which was further exacerbated by the adverse parties' actions alongside other parties. In disturbing series of events, they effectively hamstrung the proper administration of the estate, engaging in asset theft by impersonating myself as the executor. Adverse parties' harassment and stalking took a significant toll on me, causing significant harm. Eventually, I found myself named as the executor in a frivolous lawsuit, which was later deemed as malicious prosecution. Nonetheless, it caused immense financial harm and left me with virtually nothing where I stand today. Before I was appointed as the executor, I was court ordered to cover personal expenses for the estate. Over the course of the year, I endured stalking, harassment, theft, fraud, repeatedly sought the court's assistance to navigate these challenges, and I diligently followed every piece of advice that they provided. Throughout this tumultuous period, the court consistently assured me that I was protected as the executor under the provisions of the will. For a year, the adverse party manipulated court proceedings, lying about the existence of valuable assets that didn't exist, only to abandon these thoughts prior to hearings. In this tumultuous environment, I worked diligently with the probate accountant to complete the accounting. I submitted it 3 times, meticulously adhering to all instructions. However, the estate still looked certain assets checks, which were not included by the other parties. I was instructed to disperse the payout nonetheless. This action directly contradicted Ohio Revised Code 2113.301, which strictly prohibits final accounting. The executor is involved in a civil proceeding. It also avoids all attorney fees paid and mandates the final exclusion of all assets. The adverse party seized this disbursement and hired Mr. Thomas Otter. To my dismay, has furthered the crimes against me. After less than a month of being hired, Mr. Otter came into possession of over 150 pages of stolen financial information, as confirmed by my institutions themselves. This information has not yet been authenticated and has been manipulated, but it continues to be published in violation of numerous federal and state laws. The adverse party continues to perpetuate additional fraud, causing significant harm. The stolen and manipulated documentation is the sole evidence that the judgment in question relies upon. This judgment was issued before the final accounting of the estate and has effectively voided all assets. What's more, the hearing for this judgment took place unlawfully in lieu of a motion to suppress my personal information. This act directly contradicted multiple rules and due process clause of the 14th Amendment. I did not take these issues lightly, and I hired legal representation to address any problems with the final accounting and the publication of my unlawfully obtained information. Unfortunately, these attorneys made no corrections, adjusting nothing, and allowed for the publication of my information to continue. Over my final attorney to submit my completed discovery to the courts. The court cannot ignore the blatant effectiveness of counsel. However, if the accounting was indeed incorrect as claimed, the proper corrections should have been made, and the judgment should not have been determined based on these inaccurate numbers and voiding of assets. I must emphasize that under Ohio Revised Code, I am not personally liable for estate expenses, and I am not, sorry, I am not
Bless you.
personally liable for estate expenses, and I am entitled to compensation as outlined in the provisions of the will. The estate should have never been dispersed without the inclusion of the proper deduction of those expenses. As a beneficiary, I am also entitled to the missing assets. A judgment cannot be possibly determined based on inaccurate numbers, fraudulently obtained information, and voiding of all assets. Federal Rule 60 provides relief from judgment in the event of fraud, misconduct, and the unlawful obtaining and continued application of manipulated information. It falls squarely under these categories. In conclusion, the numerous legal violations, injustices, oversights that have married this case demand rectification. This appeal seeks not only to rectify these errors, but to uphold the principles of justice in the rule of law.
Mr. Jordan, just letting you know that you have about 3 minutes left.
I appreciate you. Just to reiterate, the judgment issued in the probate proceeding was premature and violated Ohio Revised Code 2117.10, which requires a full and accurate account of the estate's assets and liabilities before a final distribution can be made. The judgment was issued without all parties present and without adhering to Hamilton County local rule and procedure governing probate hearings. The judgment also appears to be based on unlawfully obtained, unauthenticated, manipulated, and stolen information, which violates my Fourth Amendment right against reasonable search and seizure. Furthermore, the unauthorized publication of this information for 2 years raises issues of privacy, defamation, and potentially violating my First Amendment rights. Thank you.
Thank you. So, Mr. Jordan, you have 1 minute, and I'm going to carry that over, so you'll have 6 minutes to reply.
I appreciate it.
Attorney Sauter.
Yes, good morning, Justices. Can everybody hear me okay? Can you hear me okay?
Yes, yes, we appreciate the
Okay.
elevation, but we are judges, not justices.
Oh, my apologies, judges. The appellee stands by its briefs. I don't want to burden the court with just rereading everything that we argued into the record already. I listened to the oral argument advanced by the appellant this morning, and I have to note that the appellant has not cited any Ohio case law that indicates that the lower court erred in its judgment when it rendered judgment in the probate case that's at issue in this appeal. Going through the assignments of error, that was the primary thrust of our response, that the court used its discretion appropriately, ruled on the facts and law that was applicable to that case, and we're eager to resolve this issue and finally close the estate some years after it was opened. I will mention with regards to the publication of financial information pointed to by the appellant. The appellant raised this issue with the court. The court dealt with it in open court on the record. The record is before this appeals court. I don't know why the appellant continues to look for relief on the publication of that financial information. It is unrelated to a trial on exceptions to account, which was the underlying court issue the litigated issue in this appeal. So the court should not consider those disclosures as there's no separate suit for any damages that the appellant claims. The personal liability that the appellant speaks about also is not relevant to this appeal, as at all relevant times the appellant was serving as executor of the estate, a position that he claims was involuntary, when in fact, of course, he enjoyed all the legal rights to decline serving as the executor during his time over the estate.
Counsel, one of the things I hear Mr. Jordan to be concerned about is the publication of full account numbers and information from the bank records in the documentation that you submitted below.
Yes.
Have those bank account numbers been redacted fully in the records in the probate court?
Yes. So I think there may be a disconnect because I submitted redacted records. There were unredacted account numbers in one of the pleadings that my firm submitted, and they needed to be corrected. And we brought redacted corrections to the court and submitted them to the judge, and the transcript would reflect that. We had them there at the hearing. We gave them to the judge and said, here you go. These are the redacted pleadings. And the judge handled it from there. But we did.
What about
comply.
the unredacted ones? Have those been sealed or stricken from the record?
I have to go back and look at the lower court docket to see because obviously we were fighting in this case, so the pleadings were referred to repeatedly. But I think the court removed or replaced the pleadings that the motions that had unredacted information, but I couldn't tell you definitively right now without going through the docket again.
Okay.
As of today.
Do you agree that that would be an appropriate remedy to take?
To seal the records?
Or strike them from the record?
Yes. And the court has a local rule on disclosure of personal identifiers, and including bank account information. So yes.
Okay, so we could go back and look in detail at the probate record to ensure that the unredacted versions have been removed in some way.
Yes. And then I just also want to emphasize, that we took steps to make that happen. So what we did is we came to the hearing. It was an issue that the executive brought up, and we submitted the redacted records in person to the judge at the final hearing on exceptions.
Thank you.
All right. So, but again, as a matter of appeal, I just want to make sure so that we have a clean record. This final judgment did not hinge on those disclosed records, right? That the exhibits that were submitted at the hearing on exceptions were none of the exhibits were objected to while we were on the record at the final hearing. The court considered all of the evidence before it and rendered the judgment that it did. So in terms of modification of the judgment or reversal of the judgment, an abuse of discretion, which is the standard here, the appellant failed to exclude any evidence or attempt to exclude any evidence that would have led to this judgment being overturned. And in fact, the appellant was representing himself pro se at the time at the final exceptions hearing after cycling through a number of attorneys. That concludes our comments on this appeal. If the judges have any further questions, I'm happy to answer.
Unless there's any questions. Okay, thank you, Attorney Sauter. Okay, Mr. Jordan has just dropped again. Okay, Mr. Jordan, so you have 6 minutes. You have 6 minutes to respond.
I feel like I missed the last 3 minutes or so of Mr. Sauter's speech. I heard was that he probably redacted, which is absolutely false.
So your position is that nothing was actually redacted?
Correct. You can go to the website and see it live right now.
Yes,
And situation. I've been begging and pleading with Hamilton County for years to get my information removed from your website, and I can't get it done. It is absolutely.
Mr. Jordan, we can't hear you.
Can you hear me now?
yes.
Okay. Yeah, the information is live on the website right now. You can go get over and see it in files right.
You just dropped.
So let's hope that the internet will cooperate and allow you to put in your remaining 6 minutes.
I hope so. As I aware, the are aware probably that I filed a motion in regards to these and foreseeing these issues with this service due to the recent natural disaster. But Mr. Sauter stating that the information is redacted is absolutely false. That information is live on the court website currently. I invite you to go look at it. It has not been resolved. I've been begging and pleading with Hamilton County for years to get my information removed from the website. It has absolutely ruined my life with fraud. I can't even get financial assistance right now in regards to the natural disaster I was involved in due to the amount of fraud associated with my name. All applicable case law is well within my brief. I believe that my brief more than states just cause for the remedies that hopefully you see fit. And I appreciate your time today.
Thank you. Unless there's any other questions from any of the judges. All right. Mr. Jordan, thank you for your arguments this morning. Attorney Souter, also thank you for your arguments. So what's going to happen now is we're going to take the case under submission. We will be writing a decision. We will be writing it in a timely basis. Mr. Jordan, we will be mailing that decision to the address that we have on file. So if there is anything to update, then it's in your best interest to let us know so that you would be able to get a copy of that decision when it gets mailed to you. Okay.
Excellent.
That, I wish that concludes all of our arguments for this morning on Monday, September 25th. And we wish both of you a wonderful afternoon and a great week.
Thank you for your time.
Thank you. All right.
The First District Court of Appeals